That there's something not connected.
That I'm a talker.
That is the reason. So, there must be one which is not connected. That is why that now it is okay.
Okay, thank you.
Based on that one.
Try. Let's try. It's okay.
Okay. Ladies and gentlemen, thank you for joining this session. We are all assembled here this hour as the committee in charge of the enforcement of the Code of Conduct, and we are here to read the judgment in the matter of the Independent Electoral and Boundaries Commission, the Electoral Code of Conduct Enforcement Committee, the complaint number 1 of 2026, in which the respondent is the Honorable Wanjiku Mohia. The respondent, being Honorable Wanjiku Mohia, is not present, but let's begin by the quorum. Begin from this side. The commissioner to my left is Commissioner Mary Karen Sorobit, a member of this committee. On my right is Commissioner Hassan Nur Hassan, a member. On my further right, Commissioner Professor Francis Adwol, and to his right we have the Secretary of the Committee, Nancy Koros. We are expecting one more member, Commissioner Andy Ritu, in a short while. The judgment. The respondent, the Honorable Wanjiku Mohia, was summoned to appear before the Electoral Code of Conduct Enforcement Committee to answer to charges of alleged contravention of the Elections Act. In particular, she is accused of having breached paragraph 6A of the Electoral Code of Conduct. She is accused of uttering words alleged to be offensive, inflammatory, and contrary to the standards of conduct expected of leaders participating in an electoral process. This complaint was lodged before this committee following the circulation of a video clip which depicted the Honorable Wanjiku Mohia at a roadside political campaign rally in Kalou, addressing a crowd of people and making from the rooftop of a car, uttering alleged hateful, offensive, and inflammatory speech. The complainant argued that the remarks contained in the video clip violated the Code of Conduct by promoting language inconsistent with peaceful campaigns and responsible political engagement. The clip in question depicts Honorable Wanjiku Mohia at a campaign rally in Kalou. She is captured speaking from the top of a motor vehicle and is surrounded by jubilant supporters. She is heard saying the following words in the native Kikuyu language. I would skip the words because I'm not a native speaker, but loosely translated, the words mean as follows, and I quote, "Organize yourselves into groups of 10 people each. When you see someone who is not from here," referring to Kalou, where she was, "where is the camera?" So she turned to ask the camera specifically to face the camera. "Anyone," she continued, "who is not from here should leave their ATM card with their wife and their title deed with their son, because by the time they wake up, they will either find themselves in hospital or in Zayuni," a term implying that they will be injured or be killed. Now, in their ordinary and plain meaning, these words imply a call to violence against any and all persons living, working, or visiting Kalou, but who are not residents or natives of Kalou. Indeed, it is a call by an elected member urging the residents to mobilize themselves in groups of 10 and actively hunt down non-residents, natives of Kalou who are not residents, and inflict violence against their fellow citizens. The complainant found no other meaning for the Honorable Wanjiku Mohia's remarks It was a clarion call to plan, mobilize, and hunt down any person found within Old Kalou and who was not a native or inhabitant of Old Kalou. Consequently, Honorable Njiku Mohia was duly summoned to appear before the Electoral Code of Conduct Enforcement Committee and face charges for the alleged violation of the law. It is not in doubt that the respondent was duly served with summons requiring her attendance before the committee at 10 a.m. The committee duly convened its session to hear the complaint at 10 a.m. on the 26th of June 2026, as directed by the summons issued and received by the respondent. Regrettably, neither the respondent nor any advocate appeared on her behalf. Mindful that electoral disputes are governed by strict constitutional and statutory timelines requiring expeditious disposal, the committee stood the matter over for approximately half an hour and waited for her attendance. Despite the indulgence extended by the committee, neither the respondent nor her representatives had appeared, and so the committee therefore directed that the proceedings would commence. Shortly thereafter, the hearing commencing, several counsels arrived and informed the committee that they had instructions to appear for her, thereby dispensing with the need for her personal presence. The respondent was therefore represented by a team of 5 advocates who introduced themselves as Honorable Edward Muriu, the lead counsel, Ndegwa Njiru, Kiragu Wadhuta, Boniface Nyamu, and Karuki Njiri, all assisting counsels. Counsels were briefed on the status of the proceedings that had taken place in their absence, and the committee chair offered to start the proceedings afresh for the sake of the respondents' advocates, since only one witness had testified by the time they joined the session. Before any evidence could be taken, counsels raised a preliminary objection challenging the jurisdiction of this committee. Counsel argued that they had obtained a Gazette notice indicating that Mr. Erastus Edung Ethekon, HSC, had been appointed the chairperson of the Electoral Code of Conduct Enforcement Committee and consequently questioned the legality of the committee sitting under the chairmanship of Commissioner Alutalala Muhwana. The committee, having had the preliminary objection, retreated to consider it and deliver ruling as required. On resumption, the committee ruled that it was lawfully constituted and vested with the requisite jurisdiction to hear and determine the complaint before it. It held that the jurisdiction is the foundation upon which the exercise of judicial and quasi-judicial authority rests. Without jurisdiction, a court or tribunal has no power to entertain a matter and must immediately decline to proceed. This was the principle authoritatively stated by the Court of Appeal in the famous case of the owners of motor vessel Lillian S. versus Caltex Oil Kenya Limited, where the court held that jurisdiction is everything and that without it, a court must down its tools. The committee applied its mind and stated that its jurisdiction to hear the complaint was predicated upon 1. Article 88(4)(e) of the Constitution, 2. Section 110 of the Elections Act, 3. The Electoral Code of Conduct contained in the second schedule to the Elections Act, and 4. Paragraph 15 of the Electoral Code of Conduct. The committee further noted that although counsel relied on earlier Gazette notice appointing Mr. Erastus Edung Ethekon, the Commission subsequently issued a valid appointment constituting the committee by which Commissioner Talala was duly appointed and designated as the chairperson of the Electoral Code of Conduct Enforcement Committee of Iebc under the law. The jurisdictional question raised by the respondent is therefore no longer res integra. The Supreme Court in the Independent Electoral and Boundaries Commission and Sabina Wanjiru Chege authoritatively settled the issue by affirming that the Iebc possesses constitutional and statutory authority to establish and operationalize the Electoral Code of Conduct Enforcement Committee for purposes of enforcing the Electoral Code of Conduct. The Supreme Court held that the committee derives its authority from Article 88 of the Constitution, as read together with Section 110 of the Elections Act and the Electoral Code of Conduct, and that the Commission exercises a lawful quasi-judicial mandate in enforcing electoral discipline during electoral processes. Accordingly, this committee is bound by that decision. And therefore, the jurisdiction and mandate of the Electoral Code of Conduct Enforcement Committee is derived from paragraph 15 of the second schedule of the Elections Act 2011. The provision requires the Independent Electoral and Boundaries Commission to establish an Electoral Code of Conduct Enforcement Committee for purposes of enforcing compliance with the code and determining complaints arising thereunder. In paragraph 15.1, it is provided that the Commission shall set up the Electoral Code of Conduct Enforcement Committee, which shall be chaired by a member appointed by the chairperson, emphasis, appointed by the chairperson, and that the Commission may nominate a member of its staff to be the secretary of the committee. Paragraph 15 further provides that the committee shall be chaired by a person appointed by the chairperson, again emphasis, of the Commission, who is qualified to hold the office of a judge of the High Court. In compliance with this statutory requirement, the chairperson of the Commission on 18th June 2026 duly empaneled a substantive Electoral Code of Conduct Enforcement Committee. The committee is vested with investigative and quasi-judicial powers necessary for the effective enforcement of the Electoral Code of Conduct. In particular, paragraphs 15.4 and 5 empower the committee to summon any person, any political party, or referendum committee, or candidate alleged to have breached the code. Conduct hearings at such place is considered appropriate, examine witnesses and other persons summoned before it, and permit parties appearing before it to be represented by legal counsel. Paragraph 15 therefore establishes the institutional framework through which the Commission enforces the Electoral Code of Conduct. Rather than leaving compliance to voluntary observance, it creates a structured disciplinary mechanism for receiving complaints, conducting investigations, and determining whether a breach of the code has occurred. Equally important, the provision safeguards the principles of procedural fairness by ensuring that persons accused of violating the code are informed of the allegations against them, afforded an opportunity to be heard, and permitted to be represented by counsel. The statutory framework serves the broader constitutional objective of safeguarding the integrity of the electoral process. It establishes an independent enforcement mechanism within the Commission, requires cooperation by political parties, candidates, agents, and election officials, confers investigative and adjudicative powers upon the committee, and promotes accountability, due process, and compliance with the Electoral Code of Conduct. These safeguards are essential to the realization of free, fair, transparent, peaceful, and credible elections. Having considered the Constitution, the Elections Act, and paragraph 15 of the Electoral Code of Conduct, together with the Supreme Court decision in the Iebc vs. Sabina Wanjiru Chege, the committee is satisfied that it possesses jurisdiction to hear and determine the complaint before it, and that it is properly seized of this matter. It is clear that this committee, therefore, has the requisite jurisdiction to hear and determine the complaint before it. The preliminary objection was therefore dismissed. Having stated and laid bases upon which we proceeded to handle the matter, allow me to go to paragraph 32 and commend that the right to a fair hearing, page 8. The right to a fair hearing must be accorded by the committee to every party before it. However, where a party voluntarily declines to exercise that right, as happened in this case, they are deemed to have waived their right to be heard. They cannot be heard when they walk out and refuse to submit themselves to the proceedings of a lawful Electoral Code of Conduct Enforcement Committee. This committee exercised its discretionary power and conducted a hearing in absence of the parties having walked out on the proceedings. In the Kenyan legal system, the right to a fair trial is strictly protected under Article 50, Subarticle 2F of the Constitution, which stipulates that every accused person has a right to be tried in their presence. However, this right is not absolute. An accused person may be tried and even convicted in absentia if they willfully abscond or behave in a manner that renders it impossible for the court to proceed in their presence. And that was held in the case of Republic versus Rotich, criminal case number A065 of 2021. The court thoroughly analyzed what happens when a defendant deliberately makes themselves unavailable to the court, fails to adhere to the bail terms. And the court specifically ruled that that would amount to an abrogation of their own constitutional rights. It ruled that an accused person of full age and sound mind who is properly notified of their trial but voluntarily chooses to absent themselves violates the obligation to attend court, and by so doing, the accused effectively waives or abrogates their constitutional right to be present during the trial under Article 50, Subarticle 2. The court further, under the deliberate conduct threshold, stated that for a court to proceed with a trial in absentia, it must first be fully satisfied that the inability to proceed normally is caused strictly by the deliberate conduct of the accused person. With respect to proceeding in the interest of justice, the court held that once a deliberate choice to abscond is established, the court is justified in directing the parties to make final submissions and pave the way for judgment on the evidence on record to avoid indefinite delays. On the issue of ultimate sentencing and the administration of justice, the court highlighted that criminal courts must balance the rights of the accused against the rights of the prosecution and the victims' families who observe expeditious justice. And regarding prevention and potential sentencing despite the physical absence of the accused person. There are more authorities which, in the interest of time, will not go to. We now go to page 10 of the judgment under the case. And if you look at paragraph 44, in the end, therefore, the law must never be defeated. The committee directed that the complainant shall proceed to prosecute its complaint, and the committee is satisfied that the respondent was afforded space and time to defend herself, but she opted to decline the invitation to be heard. The case. The committee secretary called 3 witnesses, all of whom testified under oath. PW1, Mr. Anthony Njiraini, and PW2, Ms. Nancy Kariuki, each adopted their respective written witnesses' statements as part of their evidence in chief and were subsequently examined by the committee. PW3 also testified under oath and produced the findings of the forensic investigation relating to the electronic evidence in issue. PW1, Mr. Anthony Njiraini, the returning officer for Kalou constituency, testified that he became aware of a video circulating on social media containing language which, in his own assessment, was offensive and inconsistent with the provisions of the Electoral Code of Conduct. He informed the committee that he is a native speaker of the Agikuyu language, he is Agikuyu by birth, and had carefully watched and listened to the video clip in issue. He affirmed that indeed the remarks were improper and they offended the law. As a result, he reported the matter to the Secretary of the Electoral Code of Conduct Enforcement Committee for further appropriate action. The committee finds that PW1's evidence establishes the genesis of the complaint and explains the circumstances under which the alleged breach of Electoral Code of Conduct came to the attention of the Commission. His testimony provides the factual foundation and basis upon which the subsequent investigation was initiated. The evidence of PW2, Ms. Nancy Kariuki, who is the County Elections Manager for Nyandarua County, testified that upon receiving reports regarding the circulation of the banned video on social media, she retrieved and preserved the electronic material before forwarding it to the Director of Legal Services for information and action. The video clip was played before the committee, and PW2 confirmed that indeed the evidence contained in the video clip was what she saw. And in her own words, the contents were offensive, inflammatory, and contrary to the standards of conduct expected of leaders participating in an electoral process. She told the committee that most people who reside in Kalou, including herself and other commission staff, are non-locals, and given the rising political temperature in her view, she felt threatened. The committee finds that PW2's evidence establishes the chain of custody of the electronic evidence from the point of its retrieval to its submission for forensic examination and eventual production before the committee. Her testimony demonstrates that the electronic evidence was securely preserved and handled in a manner that safeguarded its integrity throughout the investigation process. PW3, Mr. Mohammed Halake. PW3 is an investigation officer. He testified that the video was subjected to a technical examination to ascertain its authenticity, source, and integrity. The investigation was undertaken with the assistance, authentication, and verification by the Communications Authority of Kenya. The technical analysis established that, number one, the video clip had not been altered, edited, or otherwise manipulated. 2. The electronic metadata was consistent with that of the original publication. And 3. The material originated from the identified social media account. The committee finds that the forensic examination confirmed the authenticity of the video and established an unbroken chain linking its publication to the respondent. Accordingly, the committee is satisfied that the implied publication was correctly and accurately attributable to the Honorable Wanjiku Mohia, and that there was absolutely no evidence of tampering or manipulation of the material. Analysis and determination. The committee identifies the following issues for determination. 1. Whether the respondent was accorded a fair hearing, and if so, whether the committee was entitled to proceed with the hearing in her absence. 2. Whether the electronic evidence produced before the committee meets the legal requirements for admissibility before this committee. 3. Whether the respondent's conduct constituted a breach of paragraph 6A of the Electoral Code of Conduct. 4. Whether the publication breached paragraph 6A of the Electoral Code of Conduct. And 5. Whether the respondent's conduct violated Article 3, Article 10, and Article 33 of the Constitution of Kenya 2010. We examine 1. As to whether the respondent contended beg your pardon. The respondent contended through her preliminary objection and subsequent conduct during the proceedings that her right to a fair hearing had been infringed upon. The committee is therefore called upon to determine whether the proceedings complied with the constitutional and statutory requirements of procedural fairness. The right to a fair hearing is guaranteed under Article 50, Sub-Article 1 of the Constitution of Kenya, which entitles every person to have any dispute that can be resolved by the application of the law decided in a fair public hearing before an independent and impartial court of tribunal. Similarly, Article 47 of the Constitution guarantees every person the right of a fair administrative action, which is expeditious, efficient, lawful, reasonable, and procedurally fair. As a quasi-judicial body exercising statutory powers under paragraph 15 of the second schedule to the Elections Act, the committee is under a constitutional obligation to uphold these constitutional guarantees. The record demonstrates that the respondent was duly served with a summons. The complaint, witness statements, and all supporting documents in advance of the hearing. The respondent was represented by 5 advocates of her own choosing, who actively participated in the proceedings on her behalf. At the commencement of the hearing, counsel for the respondent raised a preliminary objection, as already explained, alleging an infringement upon the respondent's constitutional rights. The committee proceeded to hear the submissions from counsel before tendering its ruling dismissing the preliminary objection. The committee, mindful of its obligation to uphold the principles of procedural fairness, directed that the proceedings commence de novo upon the appearance of the respondent's 5 advocates. This was intended to ensure that the respondent, through counsel of her own choosing, had the full benefit of participating in every stage of the hearing, and that she would suffer no prejudice arising from the earlier proceedings. Following the delivery of the ruling, counsel for the respondent sought leave of the committee to consult with their client, and the committee graciously granted counsel time for that purpose, despite the very counsels having entered the committee session late. Upon resumption of the proceedings, counsel informed the committee that it was their client's instructions to them to withdraw from the proceedings forthwith, as she did not regard the committee as lawfully constituted. As put rather crassly by counsel Ndegonjiro on record, the committee was a kangaroo court, and she, the Honorable Wanjiku Muhia, would not submit herself to a kangaroo court. End of quote. The committee noted that the respondent's withdrawal was voluntary and was made after she had fully participated in the proceedings up to that stage. The committee finds that the respondent was afforded every reasonable opportunity to be heard. She was informed of the allegation against her, supplied with the evidence upon which the complaint was founded, represented by counsel of her own choosing, permitted to challenge the proceedings through a preliminary objection, and afforded an opportunity to cross-examine witnesses, adduce evidence, and make submissions. Her decision not to participate further was a matter of her own election and choice, and not the result of any act or omission on the part of this committee. The right to a fair hearing imposes a duty upon a tribunal to afford a party a reasonable opportunity to be heard, as indeed in the Court of Appeal of Kenya at Eldoret Civil Appeal number 139 of 2012, Saulo versus Cheriot, the court noted that the right to a fair hearing does not compel a party to utilize that opportunity. Where a litigant voluntarily declines to participate in proceedings after being afforded due process, such a conduct constitutes a waiver of the right to be heard, and that party cannot subsequently complain that the hearing was unfair. Accordingly, the committee is satisfied that the respondent was accorded a fair hearing in accordance with Article 47, Article 50, the Fair Administrative Action Act, and the requirements of the Electoral Code of Conduct. Having voluntarily withdrawn from the proceedings after participating therein, and after the determination of her preliminary objection, the respondent cannot subsequently contend or argue that she was denied the right to a fair hearing. The committee therefore properly directed that the hearing proceeds in her absence. Issue number 2, whether the electronic evidence produced before the committee meets the legal requirements for admissibility. The committee has considered the admissibility of the impound video in light of the relevant provisions of the Evidence Act, which governs the admissibility of electronic records. The law requires that electronic evidence be proved to be authentic and reliable, and that its integrity be preserved from the time of its acquisition to its production before the tribunal. In the present case, PW2 testified that upon receiving reports of the circulation of the impound video on social media, she retrieved and preserved the electronic material. Her evidence established the chain of custody of the electronic evidence from its retrieval to its production before the committee. PW3 testified that the impound video was subjected to a technical examination to ascertain its authenticity, source, and integrity. The investigation was undertaken with the assistance of the Communications Authority of Kenya. A duly signed record from the Communications Authority of Kenya evidencing this authentication was produced by the complainant before the committee. He testified that the impound video was subjected to a technical analysis to ascertain its authenticity, source, and integrity. The examination confirmed that the video had not been altered or manipulated, that the electronic metadata was consistent with the original publication, and that the material originated from the identified social media account. The committee further notes that the respondent did not adduce expert or other evidence to challenge the findings of the forensic examination or to cast doubt on the authenticity or integrity of the electronic evidence. Having considered the totality of the evidence, the committee is satisfied that the chain of custody was properly established and that the authenticity and integrity of the electronic evidence were sufficiently proved. Accordingly, the video satisfies the legal requirements for admissibility under the Evidence Act and is hereby admitted in evidence. The committee shall therefore consider its contents, determining whether the respondent breached the code of conduct or not. Issue number 4. Whether the respondent's conduct constituted a breach of paragraph 6A of the Electoral Code of Conduct. Paragraph 2 of the Electoral Code of Conduct outlines as follows: that the code shall, in as far as it is applicable, bind the government and every political party, leader, office bearer, agent, and member of a political party, or a person who supports a political party, and every candidate nominated under the electoral laws for any election. The committee finds that the respondent, Honorable Njiku Moya, falls within the categories of persons bound by this code. At the material time, she was a member of a political party. She was and still is a leader and an office bearer. Consequently, the provisions of the Electoral Code of Conduct were fully applicable to her, and she was under a legal obligation to comply with the requirements. Paragraph 6A of the Electoral Code of Conduct requires every candidate and political party to conduct election campaigns in a peaceful manner and to refrain from using a language or engaging in conduct that is capable of inciting violence, intimidation, hatred, hostility, or any other conduct likely to undermine the integrity of the electoral process. The provision reflects the constitutional imperative that elections be conducted in an atmosphere that promotes peace, tolerance, and respect for the rule of law. The committee is equally mindful that Article 33 of the Constitution guarantees every person the right to freedom of expression, including the freedom to seek, receive, and impart information and ideas. Political speech occupies a special place in a democratic society, and candidates are entitled to criticize their opponents and express divergent political views. However, the right to freedom of expression is not absolute. Article 33, Sub-Article 2 expressly excludes from constitutional protection that expression which amounts to propaganda for war, incitement to violence, hate speech or advocacy of hatred that constitutes ethnic incitement, vilification of others, or incitement to cause harm. The committee has carefully viewed the video, considered the words used by the respondent in their proper context, and evaluated the evidence tendered by the witnesses. The language employed went beyond the bounds of legitimate political criticism or robust campaign rhetoric. In the committee's view, the remarks were inflammatory in nature and were reasonably capable of promoting hostility and undermining the peaceful conduct of the electoral process. Such conduct is inconsistent with the standards of behavior expected of election participants under paragraph 6A of the Electoral Code of Conduct. The committee further finds that by making and publishing the remarks during the election period, the respondent failed to uphold the obligation imposed upon election participants to promote peaceful campaigns and refrain from conduct likely to inflame tensions or erode public confidence in the electoral process. Such conduct is contrary to the constitutional principles of free, fair, peaceful, and credible elections. Accordingly, having considered the evidence on record, the committee is satisfied that the complainant has established the complaint satisfactorily. It therefore finds that the respondent breached paragraph 6A of the Electoral Code of Conduct by making utterances that were capable of inciting violence, intimidation, hatred, and hostility, thereby undermining the principles of peaceful campaigning and the integrity of the electoral process. The committee cannot conclude this matter without expressing its profound concern and unequivocal condemnation of the respondent's conduct. The present crisis is clear that our streets are nearly taken over by goons. Kenya is currently experiencing a deeply disturbing wave of election campaign violence, where organized goons are deployed to unleash bloodshed, fear, and looting upon innocent citizens. We are seeing a coordinated effort to replace the democratic ballot with brute force. Political campaign rallies have been transformed into arenas of terror to the citizens. Property is being looted. Small businesses are being destroyed, and the blood of innocent Kenyans is being spilled on our streets. Iebc, through its committee, will not sanitize criminal behavior by calling it political enthusiasm. Goons are a lawless assault on our constitutional democracy, and this must stop. There is a weaponization of campaign rhetoric and dangerous tribal sloganeering, and this case by the respondent is shocking. This violence does not erupt spontaneously. It is deliberately planned, funded, and incited by politicians whose reckless language to mobilize their supporters against opponents. It must stop. The evidence brought before this committee is blood-chilling. The respondent, the Honorable Njuku Muhia, stood on the rooftop of her car at the roadside rally in Kalou and asked for the cameras, faced the cameras, and uttered words in her native language, and she told the crowd, organize yourselves into groups of 10. Anyone who is not from here should leave their ATM card with their wife and their title deed with their son. Because by the time they wake up, they will either find themselves in the hospital or in Zayuni, meaning dead. This is not a harmless political banter. This is a chilling, calculated clarion call for tribal mobilization, profiling, and the active handing down of non-residents of an area. It is an open exhortation to violence that places a target on innocent citizens, journalists, observers, and even our own Iebc staff deployed to the region who do not originate from there. And therefore, as Iebc, we suffer an institutional crossfire. There is a deplorable defiance and unfair blame to the Commission. While the Iebc is continuously blamed for failing to stop the chaos, the moment we firmly enforce the law, the guilty parties immediately accuse us of bias and favoring those leaning one side or the other. We are I beg your pardon, we are locked in an impossible vice by untruthful actors. If we remain silent, we are called weak. If we enforce the law, we are called partisan. While still we are facing open defiance from some leaders whose unhinged conduct portrays them as operating outside established rules and appear therefore to be untouchable by the Iebc. In every case, and in this very case, the Honorable Wanjiku did not attend the hearing. Later her counsels arrived, midway the weight of evidence against the respondent weighed heavily, and they refused to submit to the authority of the Iebc, contrary to the requirements of the rules under the Code of Conduct. The right to a fair hearing is the door we open as Iebc and this committee. But if you choose to walk out, you waive that right. The law will never be defeated, and it should never be defeated. The committee does not look at the political party colors, nor the statuses of those who wear those party colors. The Electoral Code of Conduct applies to everyone equally, and we shall apply Electoral Code of Conduct indiscriminately, but lawfully, firmly, and fairly. We will apply it without fear or favor. And it is in this context that we have issued summons to others who are suspected of equally flouting the laws. The public trust in this institution is fragile, and we shoulder a heavy reputation burden. We carry the heavy historical ghosts of our nation's past, which most of us know nothing about. In 2007, similar politics set our nation on fire and consumed thousands of citizens. And the late Kivuitu's ECK, may his soul find peace, was disbanded, and the commissioners then were jettisoned into the deep seas of Kenya's troubled history. Yet, young as many of Kenyans are today, they carry the burden, and we carry the burden of our past. We ought not to continue paying for the sins of our forefathers. Every goon unleashed on the street, every innocent citizen roughed up, beaten up, or business looted hurts and destroys the public trust and confidence in the Iebc. An election outcome supervised by an Iebc that is not trusted by citizens will face serious believability. It will cast doubt on the legitimacy of the winners, and that will hurt the nation's economic growth, endanger peace, and destabilize the republic. And therefore, we must learn the lessons of history. We must look at the mirrors and tremble at what it is that is facing us if we don't deal. The decision of the committee. Having considered the overwhelming evidence on record, this committee finds that the respondent, the Honorable Wanjiku Mohia, is in gross breach of paragraph 6A of the Electoral Code of Conduct. Let this decision serve as a stern and yielding warning to all political actors across Kenya that if you choose the path of incitement, the law will remove you from the ballot long before the voters do. Any conduct that departs from these principles will not be acceptable. The orders of the court are these, rather than orders of the tribunal. In the context of submission of the parties and the evidence tendered before the committee has established the respondent has violated paragraph 6A. The complainant has therefore been proved, the complaint has been proved on a balance of probabilities, being the standard applicable to these quasi-judicial proceedings. From the foregoing provisions of the law, the analysis of the facts, and the oral and documentary evidence tendered, and pursuant to the provisions of paragraph 7 of the Code, the committee hereby, A, issues a formal and resolute warning to the Honorable Njiku Muhia to refrain from ever making these utterances again, as they are configured towards inciting citizens to violence, intimidation, hatred, and hostility, thereby undermining the principles of peaceful campaigning and the integrity of the electoral process. B, issues a stern warning to the Honorable Njiku Muhia to further refrain from any and all conduct inconsistent with the Electoral Code of Conduct forthwith. C, directs that the Honorable Njiku Muhia will issue a public retraction and apology to the people of Kenya as an affirmation of her commitment to uphold the Constitution, the Electoral Code of Conduct, and to refrain from making or disseminating any statements capable of inciting violence, hatred, or otherwise undermining peaceful electoral processes. D, directs that the Honorable Njiku Muhia shall sign the retraction and apology referred to in C above publicly, in person, at the Commission's headquarters located at Anniversary Tower, 6th floor, at 4 p.m. on Monday, June 26, Monday will be 10th. July. Please, Secretary, please correct that date. On Monday next week, and shall then proceed to render the apology thereafter. E, condemns and directs the Honorable Njiku Muhia to pay a fine of Kenya shillings 1,500,000 shillings to the Independent Electoral and Boundaries Commission within 72 hours of reading of this judgment. F, issues a stern warning to the Honorable Njiku Muhia that failure to comply with the orders issued herein or any subsequent violation of the Electoral Code of Conduct shall attract further sanctions as are provided for under the Elections Act and the Electoral Code of Conduct, including but not limited to issuing an order barring her from contesting in any further election conducted by the Independent Electoral and Boundaries Commission in accordance with the applicable law. The committee makes no orders as to costs. It is so ordered. We thank you. And for avoidance of doubt, on Monday, this committee has summoned the Honorable David Gikaria, the member for Nakuru Town East, to appear to respond to allegations of breach of the Code of Conduct in the ongoing Kalou by-election campaigns. As we have said, we are consolidating our gains as Iebc. We are raiding the base because it is time that we did what we must do under the Constitution. I thank you.
Sorry, a quick one. Former Deputy President Kalou has accused Iebc that over the recent remarks about the cancellation of all Kalou by-election.
Regrettably, we have read actually the entire judgment. That's why we read the entire judgment, so that you don't leave any question